So, welcome to the second litigation funding panel, the more exciting but slightly less well-attended one, as we get further and further as we're inching towards the end. So, I'd like to first introduce quickly our panelists. Right here we have Ralph Sutton, who is the founder and CEO of Validity. Ralph was former with Bentham IMF. Next to him is Nick Rowles-Davies, who's the Executive Vice Chairman of LCM. Nick was formerly a director of Burford Capital and was also the founder of Vannon Capital. And next to him, we have Ken Epstein, who's an investment manager and legal counsel at Bentham IMF, where he and Ralph shared many happy days together.
If they weren't happy, they would have been happy, but we didn't overlap.
There are a few
we've become fast friends since, so it's okay.
There are a few topics we'd like to cover today, and just so that you understand what the difference is between this panel and another litigation funding panel you may have just attended, here we're going to sort of tackle more narrow topics, probably, litigation funding 2.0, if you will. We're going to talk about competition and returns. We're going to talk about using brokers. Do we like them? Do we not like them? We're going to talk about corporate portfolios and what those are and what it means to have a corporate portfolio these days. And finally, we're going to talk about defense funding and whether that's even a thing, and how do you pull that off as a litigation funder. So starting with our first topic, and before we jump into it, if there's anything else that you guys would like to have covered that, for example, the previous panel was unable to handle, or or something, just super narrow that you'd just like to throw out a question, even if it's in the middle of our talk, please feel free. These guys are more than equipped to handle it. So starting on competition and returns. People are predicting that with the rush of capital into the market and the increase of competition in the litigation funding space, that pricing is going to drop, take a nosedive, if you will. And before we go into that, perhaps we can start with our panelists telling us a little bit how pricing works at a litigation funder. And then maybe we'll jump into what the trends are.
Thanks, Tatiana. So pricing on many of our deals, it depends on the structure that we've used. And you probably heard from the last panel that there's two primary structures. You have a single case funding, and then you have portfolio funding. And we'll talk about defense side funding later. In the single case funding scenario, our returns are typically structured as at least in the US, as a return of our deployed capital, so a multiple of our deployed capital. The greater of that, or a percentage of the litigation proceeds themselves. That's typically the way it works at least for Bentham, on the single case side. On portfolio funding, it may be a little different. We may restrict our return to a multiple of our deployed capital and eliminate the percentage recovery. And we can do that for a couple of reasons. One is it helps with the attorneys getting comfortable with sharing of contingent fees. And two, with having a diverse set of portfolio, we have a higher degree of comfort that we're going to get paid back. And so I think we're more comfortable with getting paid from the multiple return.
Ralph, can you talk a little bit about sort of the pricing continuum, if you will? So, there are some things that you price more aggressively, other things perhaps on the other side of the spectrum. Can you talk about that a little bit?
It's totally arbitrary, Tatiana. I mean, we reach into a hat.
That's what I always thought.
And we pick out a multiple, and we just shove it down people's throats, and that's it. It usually works. People are desperate.
Sure.
What we do and when we think about a risk-return continuum, if you think about at the earliest stage of a case, when the least amount of information about the strength of the merits is known, that's, I think, what Ken was referring to as kind of a single case. From the beginning, we're looking for 3 times to 5 times our money. And whether we get that from the multiple or we get it from the percentage, that's what we're aiming for. And we're also hoping that the law firm gets the same return, right? So in a single case, we want to be joined at the hip, like Bentham, and we want the firm to do just as well as we do, and that's 3 to 5x. As you go across the continuum, let's say that a case is right before trial and they've run out of money. So now you're really talking about 2 years later, where the return structure is likely to be, I'm going to say, closer to 2x to 3x, where a lot more is known about the case. I mean, it's made it this far. There's a lot more to evaluate. You're taking less risk, both in terms of the merits issues and in terms of time. And then as you get after trial, you get to an appeal or maybe a confirmation on an arbitration award moment. We know a hell of a lot about this case, right? And we know that's maybe down to 1 or 2 legal issues on appeal, or a variety of very narrow issues, say on a confirmation of an award. So now the pricing is going to try to reach 2x, and as we'll talk about in a bit, that is one of the areas where competition has made a difference in terms of pricing. So that's the continuum. I think it's helpful to have that to set the stage and set the table, if you will, for all the things that follow.
And where do appeals and judgment enforcement fall on that continuum?
Right at the end.
Right at the end.
Yeah, where you're trying to get 2x, and there's lots and lots of competition. People know about the case because it's probably been reported upon and so on. So it's not a secret, or even a pre-filing situation where very few people can know about it.
Mm-hmm. Nick, could you, delving into the competition and pricing issues, could you talk a little bit about what's going on in the UK?
Yeah, sure. In terms of, just going back to the pricing issue, the short answer is pricing reflects the risk, which is the fundamental point of what we do. So it becomes more expensive the higher the risk is, and there's a point at which the risk is too high. So it doesn't matter how you price it. A multiple of nothing's still nothing. So we don't want to be there, right?
Right.
Just focusing on competition in London, and I think where you're really going with that is what's the effect of competition on that pricing? Is there compression? Is it changing the market? So I was told last week by a broker in London that there are 66 funders just in London. I'm not sure how accurate that is, and I'm not sure how you define what a funder is. If it's sort of one man in an office with a big bank balance and access to a lawyer, that probably makes them a funder, but are they a good funder, or are they a funder you deal with? I don't know. That remains to be seen. But there is a lot more competition. There are probably more funders in London, I suspect, than there are in the whole of the US, maybe. Certainly feels like that. That means that you have got a relatively saturated market, and most of those funders have sprung up in the last 4 or 5 years, probably in the last 6 months, in fact. I mean, when I first started funding in London, there were about 5 of us. Admittedly, that was quite a long time ago. That said, there's an awful lot of competition now. But realistically, the other side of that in terms of the competition is that there are only so many cases that are available for funding, because despite what you hear from the market, there's an awful lot of rubbish spouted by a lot of funders, frankly. And mainly what they're saying is, look, we're seeing a lot of interest from people that are looking to take our money out of choice rather than necessity, and that's absolute rubbish. That's not happening at all, particularly in London. And the reason being is the point that you raised just now, which is risk and price. Litigation funding is way too expensive for most people unless it's a purchase out of necessity, out of desperation, or out of distress situation. And I'm not suggesting that the pricing is wrong, because it isn't, because it reflects the risk of what we're doing. But it means that you're limiting yourself, or most funders are limiting themselves to a particular pool of cases which everybody's going for, and that's what's driving the competition. So what you have is a whole bunch of funders going after the same cases, and one of the things that we'll come on to is the brokers that are driving that methodology in London. So to answer your question, there is price compression, not very much, because the good funders understand how to price the risk. What worries me, and what you might see, is somebody trying to get market share that doesn't really understand risk and thinks that they can cope with the losses on a short-term basis. And that's where you might see a bit of price compression.
Can I follow up with you on a question or two I have about that? Is the London market limited pool of cases, is that reflective of the business of the UK that is conducted in London? And if you went to Liverpool or Newcastle, you might find a whole new selection, Birmingham, a whole new selection of cases?
I think the answer is probably no, simply because the values aren't there and you wouldn't get the ratios. And just as an aside, I wouldn't go to Liverpool out of choice ever. That said, there is a lot of regional business. I mean, it's more in terms of, take the insolvency market, there's a lot of lower value insolvency work which is in the regions. By that I mean Birmingham, Liverpool, Manchester, Leeds, Bristol. And that is a very underserved market. And something that we're doing at LCM is looking at that space and seeing what we can do to fund into that area, because there's a lot of work there. The challenge, of course, is in smaller cases making the ratios work of investment to return and the headroom and the usual ratios we talk about of 10-to-1 make it quite difficult.
Right. Hey, Nick, in the U.S., the adoption of funding by more and more law firms, I think, is certainly happening. But I think what you're saying is that in the UK, there's already been that adoption. And so the number of law firms that are willing to engage with you in connection with the cases is not increasing?
Yeah, so it's a professional conduct issue in the UK. You have to look at what, in a piece of litigation, the lawyers are required under the professional conduct rules to consider how the case is funded, and obviously, therefore, do they look at litigation funding. That's actually been the case since 1999, although the wording was changed a few years ago. That means that the adoption of litigation finance in the UK there's a pretty much full acceptance and take-up. And I had Patrick on a panel earlier talk about us being historically viewed as practicing the dark arts, and that was very much the case in 2009 and 10 when we were first selling this product into the London market, because nobody really understood what it meant. What you have now is, I would say, every commercial litigator in London knows something about funding. What they think funding is, what it can do, what it means, probably doesn't bear any resemblance to what Ralph or I or Ken would think it is, because we're looking at things in a slightly different way. But there's very much a take-up and acceptance. And just, I mean, comparing that to the US market, I mean, I certainly saw from maybe 2012 onwards, the lack of, or a reduction in the opposition from the contingency fee bar in the US to see us as allies as opposed to the opponents. And I think in the UK that happened earlier.
What about the pricing continuum that Ralph spoke about earlier, Nick? Is it similar in the UK, or is it a little bit different?
Yeah, the basics are the same. It's all about risk. The only observation I would make is in the UK, the statistics are that if a case is worth less than 5 million, the prospects of settlement are around 99%. Once you get over 5 million, because the figures in dispute are much greater, therefore the defense team will spend more money and can justify it, those cases either tend to settle later, or if you've got statistics of 50-50 at trial, you might want to roll the dice. So in my experience, funded cases in the UK, as opposed to, say, in Australia, where the dynamic is slightly different, funded cases tend to go to trial. Now that means two things. One, as the case continues, it becomes riskier because you lose control of the ability to have the decision made. You're giving it to a judge or a tribunal. So that's when the pricing increases, particularly in the UK market, because you've lost control. And I suspect there's a slightly different dynamic in the US, so I'm not sure.
Well, let's hear from the US. And I have to say, just from my own perspective, I'm an attorney, still practicing. But I don't see the litigation funding business as ever succeeding as a race to the bottom. I don't think that the competition is going to be such that you're ultimately going to be giving this money away. I think it's just probably going to be, the competition will increase and then it'll decrease. And you just got to stick it out. But, maybe I can hear from the professionals in the industry what they think.
I'll start it. I think that price is a function of many factors, mostly risk, but also cost of capital, other opportunities, and duration of the deal, so how long the money's going to be out there. And the risk is what the risk is, like Nick said. So if you're an intelligent funder and you are underwriting wisely, you're not going to put money out where you know that despite the best underwriting you can do, there are inherent uncertainties in the process where you're going to lose a percentage of cases no matter what. So you have to be at a certain return on those cases that you win in order to offset the losses. And if you don't get that right, then you're not going to be in the business for very long.
So I'm just thinking about Nick's crazy 66 number in London, and I was asking Ken just before our panel how many new funders might have joined the fracas in the U.S. in the last 18 months, and it's really hard to pin down. So I think there are three categories, and I think it's worth just keeping them in mind. There's the professional dedicated funders. We're losing our audience. You can't leave. We need everybody here. Now there's the professional dedicated funders, and then there's the hedge funds, and then there's the folks that need to raise capital for every deal they do, but hold themselves out as if they have capital. And those folks, the latter group,
fake it till you make it.
Fake
right?
it till you make it. Well,
Right.
I think they're not going to last because I think lawyers don't have time for that nonsense, and they're going to figure it out pretty quick as more firms do it. But the hedge funds have increasingly seen this as an uncorrelated, high-return asset class, and that's how they think about it, as an asset class, whereas I think, at least at Validity and probably at Bentham, it's about the clients, and we're trial lawyers. And so we think about it as a case, and we think about the people. So I think that fundamental distinction is going to matter over time. So let's say there's another 50 funders in the U.S. in the last 2 years. They will be divided in these three buckets, generally speaking, and they will need to have relationships. I believe this is a relationship-driven kind of product and industry, and I think it's critical because I think lawyers are trusting their clients to a funding relationship, and I think for a lot of reasons there are going to be firms that just have one or two funders, maybe three, that they go to on a regular basis they got comfortable with. That's going to get standardized and centralized, and people will get used to their documentation and so on, and that'll be very interesting. But in terms of the pricing, right, the hedge funds operate at a much higher price point. So that is, the amount that they want to commit is typically 15 and up. 10 is on the skinny side for them. Whereas for the dedicated funders, 5 million, 10 million are good standard numbers. We can get a great return, hopefully, and do very, very nicely. And so the bigger hedge fund funding amounts are going to also be priced at the cost of capital, right? So Ken mentioned cost of capital. Cost of capital means these folks only need a 15 or 20% return, whereas the dedicated funders need much more. And so the dedicated funders are bringing smarts and talent, they're bringing analysis, they're bringing all kinds of really valuable strategic advice as well as their capital, and those hedge funds are not. So
Does that mean the hedge funds are going to take on higher risk cases because they don't need the return?
I mean, jump in if you disagree, you guys, but I think the hedge funds are going to take the lowest risk cases. Or they're going to take they could take really high risk, high return cases like patent disputes where they're hoping for hundreds of millions. But you need a diversified book, even if you're a hedge fund. So the problem is always chicken and egg. How do you get the diversified book without putting too much at risk? So I do see the market diverging really in terms of pricing, where the higher dollar amount cases have lower returns and everything else is standard returns for the very reasons that we can't afford to take the kind of risk that is involved in litigation and not get those returns.
I think the other experience about, certainly from what I've seen, I mean, you have Fortress invested in pretty much every funder as far as I can work out. They've got to deal with everybody, but they're not doing that many deals because their risk appetite seems to be pretty high. Sorry, or low, depending on, I mean, they don't take any risk in comparison to the rest of the funded market. And then my experience generally in looking at hedge funds is the same in that most hedge funds have a low risk tolerance, and whilst they want to, you're absolutely right, they want to do the big ticket deals, sort of 25 to 50 million investments that probably aren't attractive to funders. The other thing I just wanted to touch on is back to competition, particularly in the UK market. I think one of the things that to me shows the evidence of the competition in the UK market in particular is the current trend for UK funders to go abroad and try and do deals in jurisdictions in which they have no experience, no feet on the ground, and they think that by going, for example, there's a lot of recent examples of UK funders going and doing deals in Australia where the Australian market has already decided they don't want to fund those cases. So it strikes me as somewhat counterintuitive that even though you can't get the deals done in London, you then go abroad to find the inventory you need to invest in, but you go to somebody else's backyard and do deals that they wouldn't do themselves. That just seems to me to be ridiculous, and I think that's probably a function of the structuring, and we didn't touch too much on that. There are obviously very different structures within the industry, but if you're one of the risks with funding is if you're a funder that's making its management fee on committed funds and you can't get inventory, the concern that I would have on that model, and I think you share this, is that the tolerance or the risk appetite increases and they start to make investments in cases that the rest of us wouldn't touch. And I think that's a bigger concern for me than anything else. That's going to damage our reputation generally with people doing deals. And we spend all our time lobbying against all sorts of people, whether it be the US Chamber or equivalent in the UK, about saying we don't fund unmeritorious pieces of litigation. That's a concern. There's certainly evidence of that because you see, and the other thing is, of course, the UK funders that are struggling to get inventory in the UK, then they go to Singapore or they go to Hong Kong or Norway or wherever it is that they've opened. But they're only going to, the problem that they're doing, what they're doing there is they're taking the same, if I would call it the same broken model, waiting for single case funding to come to you, that a distressed purchase, going and exporting that to another jurisdiction where, yes, over maybe six months to 18 months, you've got a head start because you're the first mover, but eventually somebody else will come along and there'll be competition and the same thing will happen again. And what funders haven't been good at is changing the model as opposed to changing where they do it from. That would be my other observation.
So just to, unless anybody wants to add something, just to keep this moving. Anybody, any questions on, before we move on to the next topic, on competition?
Nick, you mentioned about the use of brokers in the UK market. Could you talk about the advantages, disadvantages that they pose in terms of competition?
Thank you for that. That was our next topic, so that was a perfect segue.
Wonderful. We read the audience.
Go ahead.
Okay. So the UK is an unusual market, or probably it's unique in the UK currently that we have a broker-led industry to a large extent. That is because of history. It's because historically we had an ATE, legal expenses market, that was dealt with by brokers, Lloyd's brokers or other such insurance brokers. When the rules changed in 2013 in the UK that affected how, after the event, litigation expense insurance was dealt with, all those brokers effectively overnight lost their industry and their business, and they moved into funding. They had been doing it already, but they then were doing it full time. So we already had a set of brokers that claimed to be expert in the industry. What we now have is a sort of two-tier system of brokers. You have brokers that actually do add some value. They will prepare a case and submit it to those funders which well, they'll know the appetite of that particular fund, and they will send the cases to those particular funders. And then you have the rest of the market, which just effectively is a mailbox and forwards on everything that they receive to every funder in the hope that they will hit with one or the other of them and they'll get their commission. So these guys are paid usually on a back end out of profits, around 5% of the funder's return. Sorry, the funder's profit, not the funder's return. Occasionally they're paid a percentage, maybe 1%, 2%, or 3% of the facility. That's rare now. It used to be the case, but it was certainly, funders are less keen to do that. Now the challenge is in a market which is firstly competitive and secondly, from a funding perspective, reasonably lazy, in that they'll wait for the cases to come to the broker. The broker then chooses 3 funders. The only thing they're going to purchase on, bearing in mind, as I said earlier, regardless of what you hear, this is a purchase out of distress. It's one-off. It's transactional. It's not a continuous purchase. This is funding out of necessity in 99% of cases. So the only thing that the client, the ultimate taker of our funding, is interested in is the price, and that's what the broker promotes. What they try to do is compare. They're not comparing apples with apples. All funders are different structures, different backing, different methodology, ultimately still pricing hopefully in the same way that we've discussed, but different appetites. Now they might well pick 3 funders that appear to be the same, but they operate in different ways, and some real life examples. You're stuck with the longest term waiting for the last funder to produce their term sheet. Burford, for example, would never produce a term sheet until it had done all of its due diligence and was ready to contract. Vannin will send you any old piece of paper which tells you the terms that they've replicated on every case they've ever done in the market previously, and it'll always start at 2 times money and end somewhere different. When they've done their due diligence, they'll change the terms. Other funders, such as Colunius, do very much the same thing, or when they were in existence. So my observation on that is that, frankly, all the brokers are doing are lining up 3 funders. It's a race to the bottom, which you talked about earlier, and it's basically on price. That's why there are a number of funders, Burford being one, that has now refused to operate or cooperate with brokers and won't deal with them. That's becoming a trend, maybe not a trend, it's becoming more common, and frankly, the reason for that is if you're in the business of funding, providing solutions for clients and not selling standard products, then you don't really need a broker. If you want to do single case funding in the distressed market and wait for the broker to do your marketing, then stay and work with them. Probably the answer is you should work with both and see what happens. They will I don't know what the figures are, and you get differing observations. I think in the UK market, there's a good 50% of the market is broker-led, I would say, particularly in London.
So I like to think, I'll start and you jump in, Ken.
Yeah.
I like to think sometimes that the UK is the canary in the mine shaft for the US, but here I think it's not, and I think it's interesting why it's not. So you mentioned that AT insurance brokers ended up doing funding brokering, and I think we just don't have that layer of people. No. And what we do have is law firms who are willing to analyze cases as if it were to be a contingency arrangement or a partial contingency. So they're willing to put a few $100,000 into an analysis and then figure out the funding. That's a major difference that the UK firms, I think you told us in prepping, would not do. So the most fundamental difference in our 2 markets is the long history of contingency fee arrangements going back hundreds of years. It was an exception to champerty and maintenance at the time of the American Revolution, believe it or not. And so we have this long tradition of taking risk, which I think the London firms are getting their minds around but haven't fully absorbed. And I think that's a massive difference. And then I ask, what are these brokers offering? We're not going to trust their analysis, that's for sure. We've got to do our own analysis, and usually it's half-assed or surface, and even the best are really just preliminary gathering of some important facts, but not terribly. Or assaulting his girlfriend, and he wanted to know if we would help bail him out. I mean, that's the kind of low life, or let's just say,
wow. Hopefully nobody's a broker in this room.
Undifferentiated mass kind of person. Now there's good brokers too, and people you can rely on, and they know the clients, and occasionally the good ones do bring value. But that is a true story. But and you have a story too, so we have to hear yours. But go ahead, Ken. I guess we should.
Yeah.
be ready.
Well, I'm curious if it exists in the UK market. In the US, I've been experiencing and introduced to brokers who are more like investment bankers than brokers. And so they may not be familiar with the legal side and do the legal diligence, but they're very creative in the way they structure deals and allocate risk and the types of clients that they're pitching to. And they have added kind of a construct that's very similar to structured finance deals, where you have an SPV in place, you have a paying agent, you have something that would be like a collateral manager. And that's a structure that I think hedge funds and others are very familiar with and comfortable with. And it does add it allows you to invest in different parts of a set of cases with different risk profiles and different returns. And so that's maybe a class, you wouldn't really call them brokers. I think they're more akin to investment bankers. And I'm seeing them approach us with cases. Now, I've only really seen it on the patent side when there's enough inventory to warrant that. And it gets back to the attempt by hedge funds and others to diversify their risk by packaging these cases together. It's very similar to ABS and MBS, absent the rating, but private side stuff. And I'm really curious if you've seen that in the UK, since there's such a developed market there.
Strangely, the only time you see it is if it comes from the States. So we do get approached, but they're US-based entities. So no, that isn't something that goes on. I mean, the reality is, I think what Ralph was just saying is absolutely right. There's no historic contingency fee bar in the UK, and even though the rules changed in 2013, there's been no uptake of doing DBAs or contingency fees, because law firms in London have spent their entire careers pushing the risk onto their client. They're not about to start absorbing it now. And that requires a real change in culture or mentality. And added to that, we don't have jury awards for damages. Our judges are fairly conservative in terms of the awards that they produce. And I think all of that has meant that's been a very slow take-up in terms of contingency fees. That said, it took us 10 years, really, from about 99 to 2009 to start taking risk on what we call a conditional fee agreement, where we get a multiple of our hourly rate or an increase in our fees on success, and that's pretty much has become the retainer of choice in the commercial litigation world, certainly in the funded commercial litigation world. So, you know, it's not that I don't hold any hope for a change, but it's been very slow and it's going to take a while yet.
Just curious, has anyone in the audience dealt with a broker, you know, whether on behalf of a client or just, doesn't have to be somebody that was imprisoned. I have. It was an absolutely horrendous experience. It made me never want to deal with a broker again, although some of them might be wonderful. It was not somebody who was in prison. In fact, it was somebody who had a tremendous reputation. But, you know, you're dealing with a middleman, and you have attorneys, and you have a litigation funder full of former attorneys. So the idea that you're going to need one more layer, I frankly don't understand it. Yeah.
Like, so you're very busy and you're not going to be able to bill the time when you're interviewing funders.
Right.
So if you need funding for a case and your client says, I really want a good, you know, pick, are you going to help? And you have to say, yeah, we're going to help you. I mean, do you limit the number of funding firms that you're willing to talk to? And you say to the client, I'm only willing to talk to 3 legitimate firms. Here's one that we've used before we like. Here's another one we haven't used, but we heard good things. And you can pick a third. How do you do it?
If we believe in the case, we stick to it with the client as long as it takes.
Yeah. So you're not going to limit the time
No.
and so on. Yeah.
No. If we don't, and we have to humor the client, then, you know, we might cut that off. You know,
Yeah.
we might use clever ways of cutting that off.
Right.
But I think if it's a claim that we believe in, and the truth is, even difficult claims, once you've been in the trenches on, you know, briefing and in courts, you do, you know, we as lawyers, we get really, you know, we really own these cases.
Yeah.
They become our babies. And so honestly, we just spend the time.
I think the broker niche might expand in the U.S. because there's a need for it by the new entrants into the market. I mean, when we started Validity I've been doing this for 13 years, but we started Validity 9 months ago, and we knew that marketing was going to be all important and that relationship building was going to be all important. And so we staffed up with people who cared about other people and were great lawyers too, and that personal relationship development is very important to creating trust and collaboration to work through hard stuff. But if you don't have that focus and all you want is deals, if you have more of a Wall Street or trader or hedge fund mentality, you don't care about the relationship. You're not planning on doing 6 more necessarily. So it's like, give me a trade. I don't care who brings it. You know, broker's fine. That's the difference. And I think eventually the funders will, you know, sort of, what's the right word? They'll sort themselves out, right, among those who do care more about the clients, like Bentham does, and like Validity certainly does, and those who are just transactional and don't give a shit, and that's going to be how we, you know, sort the world out.
Hey, Ralph, you know, Bentham's independent, Validity's independent. There are now funders that are arms of different funds. So like D. Shaw is involved, Halcyon Capital. Do you think that those subset of funders within those firms benefit from the deals that exist within those organizations? Or do you think you still have to source it in the same way as you do, as we have to do, which is through relationships?
I think that's a key question for them. I mean, if you talk to David Gallagher, who was a Bentham person and a terrific, you know, lawyer and great funder, he's at D.E. Shaw, and he's the perfect person to answer. I think they do generate
deals within their network of business partners and private equity groups might have a natural pipeline from portfolio companies. But I don't think it's enough, because our rejection rate, as you probably all know, is over 90%, right? Nick, yours too, right? 96, yeah. Ours is even higher, but if I say it, I don't want to discourage people too much when I use those terms. But we get a lot of stuff thrown over the transom, and a lot of it's kooky, and you can imagine the kind of people who reach out when there's money involved. So the numbers are high, but you have to turn down a lot of things to find what you're looking for. And you have to do it graciously and carefully with respect. Well, you don't, but I do. Yeah, you don't bother. But yeah, so it requires a bigger flow, I think, even, Ken, for those kind of folks. So, and I think that's, time will tell.
And then I think they have to deal with conflicts that might exist by being part of a larger organization too. So that may be a restraint.
Before we move on to our next topic, any other questions on brokers? Go ahead.
Yeah, I just wanted to comment. I think that brokers are playing a role in terms of cases that originate from emerging markets. So I sit in the UAE and do a lot of cross-border funding and asset recovery around Africa, India, the Middle East that end up in the UK or the United States. So we've seen, mid-sized firms in emerging markets where they have a client who has a case that may end up in the UK court, but they don't know how to access funding, et cetera. So to their credit, they've reached out, and you would know some of these brokers. And I think that's the opportunity for brokers, is to take some of those best practices and really be the filter for mature funders like yourselves and help the local markets learn what they need to do to put those funding opportunities together for you guys to look at.
You're right.
That's an excellent point. Yep.
Yeah, that's a really great point. I mean, I think it's just as there's a claim that there's no regulation of funders, and I can understand why people worry about the integrity of the legal system, there are rogue people and there will be bad stories. But it would be nice if we could figure out a way to qualify brokers beyond just trial and error.
So moving on, we have a couple of topics that we'd still like to cover, but in the prior panel, they slightly touched on corporate portfolio. So I think they did mess it all up. That's true. But I think I might skip to the next topic and then leave corporate portfolios to the end. And let's talk about something that I find very interesting, which is defense funding. We as lawyers sometimes do what's called a reverse contingency, and for defense work. And what that entails is the client and the lawyer together, they figure out what they stand to lose. And if you save them any money, you get a piece of it. I mean, it's pretty much as simple as that. How does it work from a funding perspective, though? And maybe you guys can explain if there's even a market for something like this.
It's done in a corporate portfolio.
It could be. I'll start. So when Nick said earlier that there's a limited pool of cases and everybody's chasing after them, in a sense, what he's saying is what everybody knows, which is we fund the plaintiff cases or claimant cases.
Right.
We do not fund the defense side. So, with the available market or addressable market numbers that we bandy about, we tend to not slice it into defense and plaintiff, which is that's sort of a rookie error that we do, but we have to. But now we have to think about, okay, how do we actually create products and make those products, I believe, simple and compelling in order to convince very skeptical in-house lawyers that this is the right way to go. And I'll just say a tiny digression. Think about who these in-house lawyers are. They are the most, I hope I'm not offending anyone, the most conservative, right, I wouldn't worry now, everybody's leaving, boring people who left law firms because it was too much pressure, and they gave up the big dollars. Yeah, I'm going for it. You knew I was going to go ranting.
Wow,
Yeah.
I mean,
Yeah, yeah.
At least they're not in jail,
It's
right,
like
Ralph?
it's as if I had a tequila shot before getting on this panel.
No, that definitely
That
didn't
didn't happen. But they are the most conservative folks who left the very competitive and difficult world of being a lawyer and billing hours and all that for a much narrower band of compensation, right? One client and probably not that much advancement. So you're asking those people who are really worried about their vacation and their bonuses, right, to put their head on the block and try out something really new on matters that are important. That's not happening so fast, right? And what's going to be needed, I think, over, here I go, 3 to 5 years is a campaign to educate and to have academics join the discussion on their side of it, and have also fear, envy, and greed, the motivators of all great human achievements, begin to play a role, that's a joke, play a role in nudging behavior, right? So how does that work? Corporate lawsuits are assets. You're leaving them on the ground. Are you really breaching your fiduciary duties? Do you have responsibilities to the shareholders? Do you have responsibilities to your company, right? That kind of discussion is going to be commonplace. Just as funding wasn't really talked about at big firms 5 years ago, that will be part of the discussion in corporates. What does it consist of? So let's talk about it. So we can talk about, I don't want to steal your thunder, man, but you know, it's about hybrid portfolios. That's the easiest, where you have plaintiff cases and you have defense cases. I'll let Nick pick that up. But then there's also the opportunity for great firms to go to their clients and say, we will do things for you that were unimaginable, and behind the scenes we're going to have funding. So we'll give you a 50% discount on your defense cases, right? Crazy. And the funder will supplement their hourly, so they get a reasonable realization rate. But we want some kind of recovery from our holdback if we get you a great result. Doesn't have to be a reverse contingency. It could just be a multiple on the holdback. All right, so if it's a $10 million budget and it's a 50% discount, I've held back $5 million. I want 2x to 5x on that holdback if I kill this case for you, right? If I just absolutely rock your world with this case, right? And if I don't get it, by the way, I'm not giving you that ever again. That's a one-time, one and done, right? So that's one way.
It's a relationship builder.
It's a relationship builder. And you can also ask for plaintiff cases. In addition, since I solved all your problems in life, plaintiff cases. But let me pause here and let my colleagues jump in on the comments.
I mean, I agree with that in terms of, you kind of covered the topic of adoption by corporations in the context of defense side funding. And I agree that it's going to take a while for corporations to adopt. They're slow to adopt. As we discussed earlier, a lot of that is how much, the question of risk sharing and how much risk do they want to take versus others. And I think on the corporate side, it's most compelling, as Nick said, to companies and others who are in desperate need. Smaller, mid-sized companies that are in financial distress, maybe circling the drain, where the expenses associated with litigation are significant to them in the context of their overall liquidity. The defense side one is a hard one, and it's certainly difficult on an individual case basis. And when we talk about it at Bentham, we talk about mostly it as part of a hybrid portfolio. But
Have any of you, other than talking about the possibility, have any of you actually done defense side financing? No.
Yeah, in a corporate portfolio. So let me just take a step back to some of the things we were talking about earlier on. Less than 0.5% of cases that could be funded in the US are funded. And we talk about competition, but we should probably look at the addressable market. 93% of cases in the UK and about the same in Australia that could be funded are not funded. So we're only funding 7% in the UK and Australia and less than 0.5% in the US.
What do you mean by could be funded?
So cases that are brought as a plaintiff or a claimant that would fit the bill for the purposes of litigation finance. But this goes back to my point at the start, which is most funding is out of necessity in a distressed situation. So that 99.5% of cases or 93% of cases, depending on which study or which jurisdiction you're in, those are cases where a corporate client has taken the view that they'll use their own funds. And they're doing that because litigation funding is way too expensive.
Right.
it also doesn't provide a solution. So if you look at the criticisms of the funding industry, we take too long on due diligence, we're too expensive, we cherry pick, we don't do defense, we don't fund small cases, we don't fund regulatory investigations. I'll stop soon because clearly I'm sounding the death knell of the industry.
Most of them, yeah.
I agree with all that. That's absolutely what's wrong with the industry. But that's 99% of funders, and that's all those single case funders, those 65 actually, not LCM, 66 funders, less us in London, that don't provide those solutions. So corporate clients, and Ralph's absolutely right, general counsel, particularly in Europe, where most general counsel are transactional corporate lawyers, they're not litigators, and they only want to talk to you about GDPR or cybersecurity. They don't want to talk about litigation. They're leaving lots of cases on the table that don't get funded because every year they're dealing only with their defense cases. That's where their budget gets spent. That's where the difficult discussion between CFO and GC, that discussion is about what do I have to spend, not what could I spend. So those cases, so take the UK, there's still 93% of the market that we should be addressing, and that's where funders, in my view, are a bit lazy. That's where they're using brokers. They're just dealing with the stuff that comes to them. To get into that market, you have to address a number of really important factors. Why is funding not attractive to a corporate client? Well, the starting point is it's just way too expensive. So back to original question, how do you change the price? You change the risk. If you address the point of risk, it means you can reduce the price. And if you can spread your investment across a set of cases, then your risk is going to be lower because your risk of capital loss is almost zero. If you're getting 7, 10, 20 bites at the cherry to get your money back, then you can't justify pricing at 2, 3, 4 times money. You're down at 0.25 to 1.5 or whatever it is on a corporate portfolio. But the next point is, again, that something was raised on a previous panel, is persuading those corporate clients to look at their disputes as assets. So they have a value which we can securitize effectively. We're advancing money against those assets, and usually that is historically just for running the case, the legal budget to conclusion. If you add small cases and defense cases to the sort of bundle of cases that you're looking at, there's still an aggregate equity value. Defense cases have no value, but as long as there's big value in some of the claimant cases and you're funding the book, we tend to work on a 1 to 4 ratio, whereas on single cases we tend to work on 1 to 10. Hopefully I'm not going to get shouted down on that. 1 to 4, on the basis of every 100 million in value in a litigation book of business, we could probably advance up to 25 million. That means that as long as the budgets for all of the cases, whether they be the regulatory investigation or the small cases or the defense cases which are in there, they can be funded by taking the value out of the big cases. It's just like a property portfolio with an inherent value and you're advancing money against it. Now, there are a number of other reasons why corporate clients would use funding, and again, it was touched on previously. The inherent inefficiency of funding litigation off your own P&L has such a negative impact on your profit and loss. Your EBITDA reduces. That means your entire business could be reduced in value if you're valued on a PE ratio of EBITDA. The whole point being that there's a whole opportunity for corporate clients, and that is what is changing. They're really hard to do because exactly what Ralph says, trying to find the right person at the right time to talk about that is difficult. But we've spent a lot of time developing that process and working out how you do that, and we've had some realistic success since I did the British Telecom deal. Those things have changed the market a little bit. It is changing more and more. We're specifically seeing those opportunities come to us because we've got a heritage in that particular part of the market, but because also, you talk about competition, there isn't any competition in that space because nobody else is doing it. Right. So I think to me, that's the future in the industry. That's where we should be going. I'd like nobody else to follow me there, frankly, but clearly that's not going to happen. But having said that, to your first question, how do you fund defense cases? The easiest way is to put them in a portfolio with claimant work. Sorry, Ken.
Go ahead, Ken.
No, I was just going to ask whether the brokers that you see are bringing you cases that come from companies or bondholders or other groups, or is it just the relationships they have with law firms?
It's mainly through law firms, and the one thing that has changed actually is, and we were talking about the adoption of funding and how things have changed in the US and the UK market. What has changed significantly, and actually with more pace and in a really impressive way, actually in Singapore more than anywhere else that I've seen in the world, the speed of adoption and acceptance of litigation finance, not just doing it, but from the law firm perspective, seeing that, take Singapore as an example, there are a lot of really good law firms. Singapore's only recently allowed legislation for funding to be used in some discrete areas. But since the funding has been allowed, the law firms have looked at each other and said, okay, we're all good lawyers, what's our point of difference? And the one thing I've noticed in Singapore, which is only just happening in London, is the use of litigation funding as a BD tool and a way to distinguish yourself as a team of litigators trying to get more work out of existing clients and trying to get new work from new clients. And Singapore in particular has impressed me with the way in which it's taken funding and used it to show innovation, a different story to talk about, and rather than what most lawyers do, with the greatest respect, is talk about the last case they won or lost. Not a great BD approach. Not very good at it, but using funding as a way to get in the door and talk to those clients is something that we're starting to see, in particular in those jurisdictions.
What are the types of, and maybe this is a question for you again, Nick, since you seem to be doing so much of this, what are the types of corporations, the types of companies that would want to do something like this? Because I think about, we often litigate, in my firm I've litigated against all of these banks, and for some reason that comes to mind first. Take HSBC. They know they are going to, litigation is kind of part of the business model at this point. Now, I understand there are a lot of businesses that just make widgets, and that's a very different product. But is there kind of a model for the type of business that would fall into this category?
There are certainly industries and sectors which are a better target for us. So if you have a high turnover, high volume, but low margin business, then clearly any legal spend is going to have a very big impact on EBITDA. So if you can take out $1 million a month or $1 million a year or whatever, that's going to improve their profits significantly. Now, those sectors tend to be construction, outsourcing, aviation, but also sectors which are used to the business of litigation. So oil and gas and construction are particularly fertile grounds for us because they're regularly litigating. They tend to work on project-based matters, and being used to litigation, they have a lot of it, but they're also on low margins. In the UK sector last year, the construction average margin was negative. So that's a very low margin. So from that perspective, taking out legal spend when you have to litigate in any event is something which is obviously attractive. So those are the sorts of areas.
Yeah, you go.
I would add to that, companies that develop IP and technology who may have a portfolio of patents, that's, we see them pretty often, or companies that are doing cross-border transactions. You may have cross-border disputes and you may end up in a court that you're not familiar with and use it in the context of international arbitration or something like that.
So I would approach the question slightly differently, to think about which industries are by nature risk-taking, and then you're asking them to simply apply their existing risk tolerances in business to this fixed expense that they have. So take, for example, we opened an office in Houston, in part because the oil companies and the culture of energy, the energy sector, is one of wildcatting, trying to drill holes in proverbially and literally for gain, and they are more open and receptive. And you would think Silicon Valley would be that way.
Right.
My perception is that they're not. That they're already, most of them, so consolidated and gigantic that they're not interested, and they see litigation funding as a problem because they're sued all the time and they feel particularly picked on. But I do think it's a function of where are these sectors more entrepreneurial, that will, as well as these other interesting dimensions like patent and low margin.
Yeah, or where the need is. So I think the next, when the economy cycles back, I think in the bankruptcy space there's going to be a lot more using of litigation funding, both in their restructuring, pre-filing, during the pendency of the case, and certainly post-filing when you have claims administration being done through a trust that gets set up in the plan. So, that's another fertile area. It's not really a company, but you have a trust that has a corpus of assets, and its pure purpose is to resolve claims both on the defense side and the affirmative side. So I think that's a good opportunity for us.
Just quickly on this point, we covered a lot of dense territory. Does anybody have questions in terms of corporate portfolios or defense funding in the audience? No? I have to say, from my perspective, it's pretty shocking to me to hear what you guys have just said, because I would think that nobody wants to take the risk of litigation when you are not in the business of litigation. So it's difficult to understand why a litigation funder would come to a corporation and say, we're willing to take all of this off your hands, let us do it for you, and they say no. I just don't really understand what the thinking behind it is. And maybe it's just, this is how we've done it all our lives and we're not about to do something new. I just can't, I can't really understand.
I mean, I would just say in part the answer is that the products aren't simple enough and we aren't clear yet how we get our return as funders. And cracking that problem of the sources of return is, and making it straightforward is the challenge still on us. I don't think it's on the clients fully yet.
There are a couple of other really interesting observations that have picked up doing this over the last 4 years with the corporate deals. The budgeting and the financing is only one of the considerations when they're deciding whether or not they're going to take or embark on a piece of litigation. So they look at the risk of adverse publicity, all of the other considerations about what does it look like in the market, should we be seen to be doing this. It's not just about the cash. The second one is actually more important, and that's about confidentiality. In order to allow a litigation funder to finance your book of litigation, you have to open your books up to them. And you're effectively allowing all of the internal risk to be exposed to somebody that isn't part of your business. Now, obviously you can put documentation in place to ensure that confidentiality is maintained. But that's a significantly big step for a corporate client to allow a litigation funder to come and look under the bonnet, as it were, inside the business, what's going on. So there's a concern there. But the reason there's mainly a concern is actually because we're largely unregulated as an industry. Not that I'm going to espouse on whether we should be or shouldn't be regulated now, but the fact is there are only, at the risk of offending my panel members, there's only 2 litigation funders listed in London that would be, in terms of regulation or transparency, of a level where a lot of those corporate clients are prepared to cooperate. So when I did British Telecom, it was with Burford, who
Burford, I was just going to say,
clearly,
obviously, right?
yeah, large funder, but
right.
Transparent as to where its cash came from and regulated on the London Stock Exchange. LCM has done corporate deals, equally regulated on the London Stock Exchange, transparent as to its sources of capital. The majority of litigation funders, or certainly a large proportion of them, present company excluded, operate out of opaque offshore jurisdictions, operate without a clear and open source of where their cash comes from, and are not regulated. To a corporate client on the FTSE 100 or on the NASDAQ or wherever, to do a deal with that organization would be a real risk. And we've just talked about how risk-averse these people are.
Suddenly you're taking some fraudulent money that was stolen out of another jurisdiction to fund your,
I didn't say that, but I'm merely making the observation that in a largely unregulated industry, it's difficult for a lot of large corporate clients to be able to deal with a litigation funder that doesn't have the transparency or the regulation that maybe Burford and LCM do have. I'm not for 1 second suggesting they shouldn't deal with Validity or Bentham. I'm merely observing the feedback I get from the corporate world, if I put it that way.
We're going to list right away after this meeting. You should.
What do you think about the idea that, in the U.S. at least, we're only solving part of the problem that the company has? So part of the problem is risk sharing and costs, but part of the problem is for some of the smaller companies managing the process. They may not have the internal resources, human resources or otherwise, to manage the claims, make good decisions, things like that. In the U.S., we can't manage that process. In some other jurisdictions, you can take more of a managerial ownership.
Because of champerty and maintenance.
Because of champerty and maintenance.
Yep.
So from the perspective of the company, yes, what you're offering helps on the economic risk side, but it's not a one-stop shop for solving all the problems.
I always admired the way Bentham IMF in Australia would manage the litigation for the clients who this could be their only piece of litigation their entire life and get paid for it. And I always understood that the ethics professors guiding us told us champerty maintenance is the reason that it would be offensive to do so in the US. But even in the jurisdictions where champerty has been abolished, you don't find that. And everybody here in the States is concerned to do that. But it makes so much sense. We use bankers to structure transactions. We use accountants and auditors to help us do those things. Why in the world is it different? I guess there's no answer. But if anyone wants to venture, I'm curious. Nope. Yeah, it's tricky.
What about
We're dying up here, guys. Come on.
what about dealing with CFOs of companies instead of general counsel?
Well, that's actually exactly how the deal gets done, because
Okay.
and that is probably why there haven't been thousands of these types of deals done, because actually dealing with the general counsel is not the correct method for the purposes. This is entirely a finance situation. It's not a legal situation. But just the point that we're just talking about managing litigation, the whole issue here is that a funder has managed many, many more pieces of litigation than most corporate clients. And the corporate client's core business is, if you're a telecoms company, it's dealing with telecoms, it's not managing litigation. But actually the way that these deals get done mainly is by us partnering with their trusted advisors and them understanding that we're merely finance. The advisors will be advising them, and they will still make the decisions themselves. So we might be managing the process, but we're not taking the decisions for them, and that tends to be where they get more comfortable. But we do manage the process, because if you think we're sitting in a very different position, usually if you're a funder, you're brought in at the last minute because there's been fee fatigue or nobody knows how they're going to pay for the case at the start, and we get slotted in right next to e-disclosure and document management. When you're working with a corporate client on a corporate portfolio, you're sitting right at the top of the waterfall of influence, if you can call it that. What you're doing is talking directly to the decision makers at that business, not only about what cases should be run or go in the portfolio, because that's an ongoing discussion, and there's longevity to the relationship. It's not one-off and transactional, but you're suddenly in control of where the work's going. So from a lawyer's perspective, that puts us in a very different position, and one that usually works better because we're working hand in hand with the lawyers and choosing which panel firms and how that should operate. So to a certain extent, managing.
I was going to wonder whether that, your position in sitting side by side with counsel may actually cause counsel to be concerned that you have maybe influence over the corporate management, that, if you weren't there, that they would have a direct relationship without having your influence.
Well, they still have the relationship, but we're writing the checks. I mean, what it does is it makes us important both to the client and the law firm, because one of the law firms we deal with, their largest client pays them something like $25 million a year. If we do a corporate portfolio deal that might be something anywhere from $10 to $75 million over 18 to 36 months, all of a sudden we're writing really large checks. That makes us quite important from their perspective. So I don't know whether they're concerned about it. They're getting more work as a result of it. They're getting more work from existing clients, and they're getting new work from new clients because we're taking them in and dealing with it that way. The challenge, which is one that is worth identifying, you can't do that with every law firm for obvious reasons. So it does narrow down your ability to work with every law firm, but then we don't work with every law firm. So I don't see it as a massive issue at the moment.
Have you, maybe a slightly off-topic question, but just something that I'm personally interested in. Have you ever wanted a deal, whether it was for publicity's sake or some other reason, where you've taken a much sort of, I would say, your pricing has been much more competitive. Let's put it politically correct.
Sure.
So there is
not terrible pricing, right? We still have our disciplines, but I would say we've certainly, to build relationships, or because you're asking about public exposure.
Well, I just think about the way that the law firm works. We have, I work at Baker Hostetler, conservative, 100-year-old law firm. But there'll be a deal, there'll be this case out there, and you want your name on it, and you're willing to do a lot, despite the fact that, otherwise you wouldn't. And I wonder if litigation funders work the same way, or is there just certain parameters within which you have to work?
The parameters are narrower, probably. You probably have more discretion. But I think we would certainly chase things and lower our pricing to get them. We've done it, and we'll see how they work out.
Yeah.
There's different ways to skin the cat, right? I mean, if you want to, sometimes for relationship purposes, maybe we'll go below our minimum investment threshold, or we'll give away some part of the upside. So instead of structuring it as the greater of a multiple or a percentage of the proceeds, maybe we'll either reduce the percentage of proceeds or eliminate that altogether and just base it off of a multiple. So yeah, we do make changes.
What about LCM?
I was hoping you'd forgotten me. Look, there are always deals where you might not adopt such a rigid approach, but ultimately we still have the same duties to our shareholders and we have to produce the right return. So the reality is there are things that we can do to try and make the deal more attractive, but you can't be silly about these things, and you have to price the risk. So I suppose the real answer is yes, we do think about it, but within sensible parameters.
Are those parameters more strict because you're a public company?
Probably because it's entirely transparent, and
Right.
We have to report anything to the market of significance, and that means that we're very open about what we do and how we do it within the realms of the usual confidentiality. So probably yes.
Okay. So maybe don't rush to go public. I had to temper the previous. All right. Well, thank you, everyone. That's all we have for you today, and thank you very much to our panelists. Yeah, of course.
Yes, it's starting. It's starting. I think both are starting, and I think the inventory is just too thin right now to make a market out of it. But as you're still all here, I just want to say a special thanks to Tatiana, who came in and moderated our unruly crowd of a panel here so graciously and intelligently. Thank you.
Thank you, Rob.